Thank you for tuning in to Brock Eichler Talks, where we explore and discuss today's trending legal topics. My name is Joseph Cameron, and I'm here today with Andrew Macklin. How are you doing, Andrew?
I'm doing well today. Thanks, Joe.
All right. For those who are unfamiliar with you, if you can give yourself a brief introduction.
Sure. Andrew Macklin. I'm a member here at Brock Eichler. Been in practice for about 20 years. I'm admitted to the bars of New Jersey and New York and various courts in those states. Over the last, I'd say, 10 to 12 years, my focus has been on construction litigation, so I get involved in lots of disputes of all shapes and sizes in the construction industry, representing property owners, project managers, general contractors, subcontractors, pretty much everyone who gets involved in construction.
And speaking of construction, I know there are some issues and questions that might arise when people are doing home improvement projects. So if you could just briefly tell us really quick what we're going to be going through with these 8 essential questions that you have.
So there are very specific regulations that govern what home improvement contractors can do, can't do, must do, and mustn't do on home improvement projects. And that's any home improvement project from $500 up. There are a lot of tradespeople, contractors I know and who I've worked with who have been working for 30, 40 years who don't know that these regulations are in place. Of course, most homeowners don't, and some of them find out the hard way what these regulations are and why they're in place. But knowing about them in advance can help both the contractor side and the homeowner side know what their rights and responsibilities are to avoid what can be major problems with these kinds of projects. So I'm going to focus on specifically home improvement projects more than $500 and the kinds of things each side can do to protect themselves in light of those regulations.
So let's hop right in. Should a contractor and customer have a written contract for their project?
Absolutely, 1,000%. You should have a written contract, and I would expand this beyond, of course, residential, home improvement projects to commercial, industrial projects. You need to have a written contract so everyone knows what their rights are. There's also issues that can arise with insurance. If you don't have a written contract, your insurance company is not going to be happy with you. But when it comes to home improvement of more than $500, you are required by law to have a written contract. Now, if you're the contractor, that law puts the responsibility on you to ensure that you have the written contract, that it says everything that is required to be in it pursuant to the law, and that everybody sign it. But even as the homeowner, even though it's not your responsibility technically under the regulations, you want to have one so you know what to look at, to know how you're supposed to act on the job, what your contractor is supposed to be doing, so you know what to look for as your project progresses.
Yeah, that sounds extremely important, and I'm sure something could easily go wrong if you don't have those protections in place. So what should a construction contract say?
Basically, it should lay out all the terms that you and the contractor, or if you're the contractor, you and your customer have discussed. For example, how and when does the contractor get paid? Are you getting paid a percentage up front, a percentage in the middle, and a percentage at the end? Are there certain benchmarks for when you're supposed to be paid, depending on the size and scope of the project? There should be a procedure for inspecting the quality of the work when the contractor applies for payment. You should have dates in there. When's the job going to start? When is it supposed to be completed? Is that going to be triggered by the issuance of a permit, or is it just going to be triggered on a certain date if it's not, for example, a job that requires a permit? What happens if there are delays on the project? We all lived not too long ago through the coronavirus pandemic, when basically everything ground to a halt. And of course, since then, material costs have escalated quite a bit. So what happens if something that you don't anticipate happens while your project is ongoing? How do you deal with it? It should have a description. This is a requirement under the regulations. It should have a description of the work to be done and the materials to be provided. If it's important to your customer, or if you're the customer and it's important to you to have Andersen windows installed, your contract has to say that Andersen windows will be installed, and the contractor has to honor what it says. In other words, can't promise you Andersen windows and then go get replacement windows from Home Depot that aren't Andersen and install them because they're cheaper. Any changes to the contract, so work is underway, a contractor, for example, finds something behind the walls that you didn't expect to find, or say you're looking at it and you decide, you know what, I don't want this to look like this, I want it to look like something else, you decide to change your mind, you have to have those kinds of changes in writing signed by both parties. And if you don't do that, it's really on the contractor, who then has the problem under the regulations. If they are seeking payment for something that's not in writing, they might have a big problem under the regulations. It should also specify whether someone other than the contractor is going to be responsible for any portion of the work. So in other words, if the contractor is not only just going to subcontract a portion of the work, but is going to say, you know what, I'm not even going to be responsible for this portion of the project. You can talk to person X about this portion of the project. The contractor is required to put that in writing. And really, if you're the homeowner, you should ask your contractor up front whether and to what extent this project is going to be subcontracted. Because, you know, you're hiring this contractor who's in your house and is looking you in the eye, but if he or she is not the one who's going to be doing the work, or employees are going to be doing the work and it's going to be some other company, you might want to know who that is. You might want to have a chance to look into them before they start swinging a hammer inside your house. And the last thing I'll mention, and this is another requirement under those regulations I mentioned, the contract should state whether the contractor has liability insurance and workers' compensation insurance. Because insurance is there, obviously, to protect against something awful happening. Sometimes awful things happen. You want to make sure that you are protected by having a contractor working on your house who has those kinds of insurance that can step in if something really goes wrong. And if they tell you that they have it, they put it in the contract, just ask them for some kind of proof. The insurance companies or even their broker will give them what's called a declaration page, which will just give you a summary of the coverages. And you may want to ask if you can be named as an additional insured under those policies.
So we may have some listeners that are thinking, we have started a project and we do not have a written contract. What should someone do if they started a project without a written contract?
So if it's home improvement, like we've been talking about, of more than $500, under New Jersey law, the contractor has the legal responsibility for having that written contract that sets forth things like the price, the timeline, the materials, some of the things I mentioned earlier. If you're the homeowner and the lack of a written contract causes some harm to you, in other words, there's confusion over the timeline for the job, there's confusion over the materials that were going to be used, and as a result it costs you extra money, you could have claims against the contractor. You could ask under the law for a refund of the money the contractor received as a result of the bad conduct. You can ask for damages, which under New Jersey's Consumer Fraud Act can be multiplied by 3. You can ask for attorney fees and costs, and you can also even ask for dismissal of any claim the contractor might want to make for unpaid contract amounts. Now, on the other side of the coin, if you were the contractor, even after the job is underway and you realize you don't have a written contract, you still might want to put one together and present it to the homeowner and just deal with the issue now, because if you wait until the end, you could be inviting all those problems I just mentioned. Always a good idea to have a written contract, even if you've already started without having one.
So we probably have a lot of homeowners and contractors listening. What should they do if the other side is not doing what he or she is supposed to be doing?
So the number one answer is, what does your contract say you can do? Most construction contracts will have some provision in there for what happens when one side or the other defaults. So if you're the contractor, the way the homeowner defaults is either by not paying you, or perhaps by interfering with the work you're doing or not making the property available to you so you can do your work in the time that you promised to do it in. And the contract should say what happens in those scenarios. Now, on the other side of the coin, for the homeowner, if the contractor is not getting the job done fast enough, if you're not happy with the quality of the work, you, depending on the contract language, you may be able to terminate them. You may be able to exercise remedies that are under the contract. You may also have some of the remedies that I mentioned earlier under the Consumer Fraud Act, the Contractors Registration Act, or the Home Improvement Contractor Regulations. But this just goes back to the first question of the day, which is you got to have a written contract, and it should have information in it for each side to know what they're supposed to do if the other side doesn't perform properly.
And as we both know, home improvements don't always go as planned. What if I'm the homeowner and my contractor claims he or she is owed money? Can they place a lien on my property?
They can. Under New Jersey's construction lien law, a general contractor, so the person that you've entered a contract with to do work on your home, a subcontractor, so the person that general contractor subs some portion of the job to, or a subcontractor, which, believe me, actually happens if the subcontractor even subcontracts out a portion of their work. Those 3 tiers can have lien rights on your property. Now, there are very strict and specific timing requirements and form requirements for the liens. Under residential construction, the contractor has to file what's called a notice of unpaid balance and right to file lien within 60 days of the day they last did work toward the contract on your property. And then they have to notify you and give you an opportunity to do like an expedited arbitration proceeding before the American Arbitration Association. And then some arbitrator within the next 60 days decides very quickly whether the contractor can actually file a lien. The lien has to be based on a written contract, and it has to be signed by the party against whom enforcement is sought. So in the case of a direct contract between you as a homeowner and your general contractor, you as the owner have to have signed that contract. in order for the contractor to have lien rights. It can be a little more complicated where there are multiple tiers where you as the owner won't have signed any subcontracts, but the party against whom enforcement is sought has to have signed the contract in order for anyone to have lien rights. For commercial projects, I'm going to digress just a little bit, you don't have to file that notice of unpaid balance. You can just directly file a lien, but you have 90 days from the day you last did work to file a lien. So the short answer is, if you're the homeowner, they can file liens, but they have to first file a notice of unpaid balance, give you notice of it, and you have an opportunity to challenge it and hopefully convince that arbitrator that the contractor shouldn't be allowed to file a lien on your property.
What should someone do if a contractor does file a lien on their property?
The short answer is you have to get an attorney that's experienced in these kinds of matters to represent you. If you disagree with the lien, you can demand that the contractor either withdraw it or file suit on it, which they then have to do within a certain number of days, and if they don't, the lien is discharged. You can also request a certified list of all the subcontractors and material suppliers who are out there who could possibly have liens on your property, so that if people start coming out of the woodwork, so to speak, and filing notices of unpaid balance or liens on your property, your GC's got to give you the list of all those potential people so you know who you're dealing with. But for residential, you have a very early opportunity to challenge their lien rights right up front, and if they either don't have a written contract or they don't have proofs of progress of the work being done, you can hopefully knock that lien out very early in the process.
One really common question I'm sure a lot of homeowners have is, how can they make sure a contractor is doing what they're supposed to be doing once a project starts?
Be there. I mean, in a lot of instances, it's impossible not to be there because it's in your home, right? And unless it's such a major renovation that you have to vacate the project while it's ongoing, just be there and keep an eye on what's happening. Have the contractor, when it's time for them to apply for a payment, have them walk with you through the job to show you what's been done, to show you the materials, to show you the progress. For larger jobs, I often will recommend to people that you pay a couple extra dollars to have your architect or your engineer, whoever's involved as a professional on the job, pay them to do what's called site administration, so that when one of those payment requisitions comes in, you can send it to your architect. And your architect, who might have a better idea what they're looking at than you do, can go look at the progress, look at the quality, and make sure the contractor is keeping up with what they're supposed to be doing. Communicate is number two. So you got to be there, you got to communicate. Ask questions about when things are going to happen. Follow up to make sure they happen as and when the contractor says they're going to happen. If you're the contractor, the same rule applies the other way. Communicate with your customer, your client. Make sure that they understand what you're doing so there's no confusion, because confusion leads to disputes. If the job lags on the homeowner side and on the property owner side, put your concerns in writing. Have some kind of a record that somebody like me can use down the road if, God forbid, you wind up needing to find a lawyer. Email is generally acceptable. You don't need to write fancy certified letters. Just ask for confirmation as to when and how the job's going to get back on track. You can also, some things you can do without even needing to rely on your contractor other than looking at the work. Go to the town, pull the permit file. If you're not sure what's going on with the inspection progress, you can make an Open Public Records Act request. If it's your own property, you can just walk right into the building department and they'll give you the permit file to look at, so you can verify the status of what's happening. Has there been a rough plumbing inspection? Has there been a rough electrical inspection? That's another way, independently of your contractor, if a little bit of the trust has faded, that you can independently verify that what the contractor is telling you is accurate.
And if a disaster strikes and the homeowner or contractor needs to sue, are they better off in court or arbitration?
I'm going to give you the quintessential lawyer answer, which is it depends. It really depends on how strongly you, or perhaps more importantly, your experienced attorney in these matters, feels about your position. There's benefits and disadvantages of each arbitration and litigation. Some advantages of arbitration. Arbitrators in construction arbitration generally know how these projects work. They know the vocabulary that's involved. They know the different elements that go into a construction project. So I wouldn't have to educate that arbitrator as much as I would a lay jury who's never been involved in construction contracting work. The process in arbitration is generally a bit shorter and more flexible in terms of things like the rules of evidence, and for scheduling. You generally get a quicker result in an arbitration, particularly in a residential setting. Disadvantages, though, of arbitration: the judge and the jury want to be paid, right? Your jury in the superior court or even in federal district court, they get paid out of everyone's taxes. But when you have an arbitrator, or perhaps worse, a panel of 3 arbitrators, each of those folks wants to get paid on an hourly rate. So it's a bit expensive on that side. If you're in the AAA, the American Arbitration Association, they also want to be paid their administrative fees, which can be pretty expensive depending on the size of your project. Another possible disadvantage of arbitration is that the proceedings are confidential. So if you think your contractor really did a bad job or really committed fraud on you, for example, that's not going to be a matter of public record. It's going to be easier for the contractor to sort of keep that private. There's also, some people are concerned about the possibility that there could be influence on the arbitrator. Since these are construction industry arbitrations, people get worried that, well, the arbitrators are going to somehow know the contractor. I'm not usually as concerned about that unless I'm dealing with a really large contractor, but the arbitrators are required to make disclosures of any possible facts that could lead someone to think there's a conflict of interest. So if there's some prior relationship between the arbitrator and that contractor, they have to reveal it, and you're allowed, of course, to object to having that arbitrator hear your case.
Thank you, Andrew. This has been really eye-opening. If anybody has any questions or they want to retain your services, how can they get in contact with you?
Sure. Well, it's easy enough to get in touch with me by phone. My direct dial here is 973-447-9670. Or you can always email me at amacklin@brockeichler.com. That's AMACKLIN @brockeichler.com. And if you're a contractor, make sure your contracts say what they need to say. Make sure you're registered with the Division of Consumer Affairs. And if you're a homeowner about to embark on a sizable home improvement project, it might be a good idea to give me a call. But at the very least, make sure you're familiarizing yourself with these regulations and you know what your contractor has to put in writing to you at the beginning of your job. And good luck out there.
And for more information on Andrew, you can visit brockeichler.com and then search our professionals page. Thank you for tuning in, and we'll see you next time. Thank you for listening, and for more information, please visit brockeichler.com. Brock Eichler LLC is a full-service law firm based in Roseland, New Jersey. With over 80 attorneys, the firm is focused on the following practice areas: healthcare law, real estate, litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax, and cannabis law.